Chapter 7, Real Estate, Federal and State Laws. In Chapter 7, you will be presented with the Civil Rights Act, Fair Housing Act, Landlord and Tenant Act, prohibited activities, special exemptions, deposits, advance rents, and evictions. In the end, you'll be able to describe the features of the Civil Rights Act of 1866, 1964, and 1968, and explain the significance of the Jones versus Mayors court case. You'll be able to list the property exempt from the 1968 Fair Housing Act and describe the types of discriminatory acts that are prohibited under the Fair Housing Act. Describe the objectives and major provisions of the Americans with Disabilities Act. You'll be able to describe the major provisions of the Interstate Land Sales Full Disclosure Act. You'll also be able to describe the provisions of a Florida Residential Landlord and Tenant Act. Chapter 7's vocabulary. This one's pretty short. Not too bad. The Civil Rights Act of 1866 prohibits discrimination based on race in all real estate transactions. There are no exceptions. The Civil Rights Act of 1964 ended racial segregation in schools, workplaces, and public accommodations. It prohibits discrimination based on race, color, religion, or national origin in public accommodations and public facilities. The Civil Rights Act of 1968, the Fair Housing Act, also known as Title 8 of the Civil Rights Act of 1968, made discrimination illegal in sales, leasing, advertising sales or rentals, financing or brokerage services if based on race, color, religion, sex, or national origin. In 1988, the Civil Rights Act of 1968 was amended to include handicap status and familial status. Familial status is families with children under 18 and pregnant women. Handicap status is any physical or mental impairment that interferes with normal life functioning. The Fair Housing Act of 1968 created to eliminate discrimination based on familial status, race, sex, handicap status, color, religion, and national origin. There is no protection under the Federal Fair Housing Act for age, occupation, marital status, sexual orientation. However, state or local laws may add additional protected classes. Discrimination in general. Federal law prohibits discrimination based on any of the 7 protected classes. Discrimination may be legal if it does not violate federal, state, or local laws, such as discrimination against smokers, discrimination against pets. Licensees should be familiar with the laws in the area where they operate. Fair Housing Poster pledges adherence to the Fair Housing Act. It's displayed at real estate brokerage offices and mortgage lending offices. It's available free from HUD. Failure to display the poster may be used as evidence of discrimination in a complaint. The Fair Housing Act covers single-family housing, government-owned housing, privately owned if the licensee is employed to sell or rent the property, property owned by a person who owns 4 or more residential units, or an owner during the past 2-year period sells 2 or more houses that are not owner-occupied. The Fair Housing Act also covers multifamily housing with 5 or more units, as well as 4 or fewer units if one of the units is not owner-occupied. Housing for older persons. Exempt from the familial status protection provided one of these 2 things are occurring. Either all the units are occupied by persons 62 or older, or At least 80% of the units are occupied by one or more persons 55 or older. Transactions that are exempt under the Act. Exemptions apply under two conditions: that a real estate licensee is not involved and there is no discriminatory advertising. Exempt transactions would include seller who owns 3 or fewer single-family dwellings, a seller that was not living in the house and was not the most recent resident when the property was sold or rented. There's one exempt sale in a 24-month period. Rentals in multifamily dwellings with 4 or fewer family units and the owner lives in one of the units. But if it's racial discrimination, the Civil Rights Act of 1866 applies. You never, ever, ever, under any circumstance, can discriminate against race. There are special exemptions. Housing operated by religious organizations and private clubs not operated for commercial purposes may discriminate. Religious organizations may restrict the units to the members of their religion provided they do not discriminate in accepting membership. And private clubs the same. They may restrict their units to their members. Prohibited activities: steering, blockbusting, and redlining. Steering is channeling home seekers to or away from neighborhoods. Blockbusting is using the entry or rumor of entry of a protected class to urge owners to sell. Redlining is denying loans or insurance coverage or different terms and conditions for homes in certain neighborhoods. Some other prohibited activities are: you cannot refuse to rent, to sell, to negotiate, or deal with a member of a protected class. You cannot quote different terms, conditions, or privileges for buying or renting. You cannot advertise that housing is only available to people of a certain race, color, sex, religion, national origin, handicap status, or familial status. You cannot deny membership or use of any real estate service. You cannot make false statements concerning availability of housing for inspection, rent, or sell. Florida Fair Housing Act has the same protected classes as the federal law, which prohibits refusal to rent or sell housing, falsely deny that housing is available for inspection, rental, or sale, refusing to make a mortgage loan, imposing different conditions or terms on a loan, threatening, coercing, intimidating any individual exercising a fair housing right. And they cannot refuse to make reasonable changes to a dwelling to accommodate a disability. Enforcement under the Fair Housing Act: complaints are filed with HUD. There's a 1-year time limit. Action is taken by the Department of Justice, and civil suits are filed in the federal district court. Real estate licensees have the responsibility and the liability not to allow discrimination. Americans with Disabilities Act 1990. That protects employment and accessibility rights of individuals with mental and physical disabilities. Disabled cannot be denied access to public transportation, public accommodations, and commercial facilities. This includes real estate brokerage offices, even if located in a private residence. Modifications may be required if readily achievable. The Florida Americans with Disabilities Implementation Act is what oversees this. Interstate Land Full Disclosure Act. Federal law regulates the sale or lease of land. It's administered by the Consumer Financial Protection Bureau. It requires certain developers must register developments and disclose to prospects facts regarding the real estate. There are two components. There's a registration requirement and the property report. Developers must register subdivisions of 100 or more lots with the Bureau of Consumer Financial Protection. Developers of 25 or more lots must provide the purchaser with a property report disclosure before signing a contract, and the buyer has 7 days to cancel. Buyers who did not receive the report prior to signing the contract may cancel within 2 years. Florida Residential Landlord and Tenant Act placed landlord and tenants on equitable legal basis. It applies to renting of dwelling units, not transient facilities, not renting mobile home lots, and not commercial leases. Deposits and advance rents. Now, we're not talking about the deposits and advance rents that a brokerage holds in a property management company. We're talking about Joe Public that manages his own rentals and collects the rent, finds the tenant, and does it all. Okay? Landlords must account for deposits and advance rents in one of 3 ways. They either hold the money in a separate non-interest bearing Florida bank account for the benefit of the tenant. They can hold the money in a separate interest-bearing Florida bank account and pay the tenant at least 75% interest or 5% per year simple interest. Or if Joe Public does not want to bother with a separate account, they can post a surety bond for the amount of the security deposits and advance rents or $50,000, whichever is less, and pay the tenant 5% per year simple interest. Landlords must provide written notice to tenant within 30 days of collecting the deposits of 5 or more units. Broker property management. Now we're talking about if it's a property management company within a brokerage. If a broker holds the funds on behalf of the landlord, brokers must abide by license law regarding escrow funds. Remember the 3 days getting in? Okay. Deposits and advance rents are trust funds that must be deposited into the broker's escrow. It's best to open a separate escrow for property management, but not required. We talked about that earlier. $5,000 of the broker's funds, I call them buffer funds, are allowed to maintain the account, and sales associates must deliver rent and rental deposits to the broker by the end of the next business day. Rentals to active duty military. They must approve or deny a rental application within 7 days. The service member must be notified in writing regarding the approval or denial. If denied, they must state the reason for the denial. Obligations to maintain the premises. The landlord and tenant both must meet health and building codes. The landlord needs to provide working heat and running hot water. Insect extermination, garbage receptacles, and pickup. Working smoke detectors. The tenant needs to use reasonable care in the operation of the equipment and not disturb the peace of others. The landlord's access to the premises. The tenant must allow the landlord to enter the property to make inspections, provide services, make repairs, and show property. Landlord may enter the property at any time in the case of a bona fide emergency. Otherwise, the landlord's obligated to give the tenant reasonable notice. Notice it's 12 hours, not 24. Vacating the premises. When the landlord is holding a security deposit, they must return to the tenant within 15 days if no claim is to be made. They must send written notice by certified mail within 30 days if a claim is to be made. The tenant is allowed 15 days to respond to the landlord's written claim, and disputes are handled in the civil court. There is an exception to conflicting demand rules if the broker is holding the security deposit. The commission wants them to take it straight on to court. Termination of a rental agreement by a tenant. The tenant has to give the landlord a 7-day written notice, and the rent may be reduced by the court if the tenant desires to remain on the premises. The notice must be delivered personally or mailed. What this is talking about is if the landlord hasn't made a correction. Let's use an example as a hot water heater. The hot water heater went out. The tenant notified the landlord. 7-day notice. If the landlord has not fixed it, then the tenant has the right to terminate the rental agreement. The rent being reduced means that the court can reduce it, not the tenant, if the tenant decides to stay in the property. Termination of rental agreement by the landlord. Now, this time it's flipped over. Again, there's a 7-day written notice and a 3-day written notice. The 7-day written notice is when the tenant is not complying with some rules or regulations. The 3-day written notice is for non-payment of rent. The notice must be delivered personally, mailed, or it can be posted on the door. The eviction requirements. Okay, so it's time to evict the tenant. The landlord must have notified the tenant in writing, either utilizing the 3 business day if it was for rent or the 7 day if it was for not abiding by some rule. After that time period is up, the landlord can file a complaint for eviction with the court. The tenant has 5 days to respond to the complaint. If the tenant continues to occupy without responding, the landlord needs to obtain a final judgment from the court. There's a 24-hour notice posted on the door, and then the landlord goes back with the sheriff, and the sheriff signs a writ of possession, escorts the tenants out, and hands over the property to the landlord. Sale of lease homes. Unless specifically stated in the lease agreement, sale of rented property does not terminate the lease. If the lease continues after the sale, the security deposits and advance rents must be transferred to the new owner, and this requires a final accounting to the tenant at the time of transferring of funds.